Hello, we're back. I have to apologize. I said 6 jurors. It is 4 preempts. The reason I was thinking that, and I thought about it on the break, is that I was thinking about a civil jury has 6 jurors, right, and criminal has 12. And I'm sorry, that's where I got the 6 in my head, and I apologize.
Okay, real quick. Both the defense and the prosecution get those 4 or more preempts.
Correct.
Because they're trying to get people that aren't necessarily on their side, but aren't obstructed from giving a fair result.
Yeah, because the thing is, you don't want to make one. I mean, if you find a juror that's like saying everything that you want, you're thinking, oh God, here it comes. That's the first guy that the prosecutor is going to kick off.
Right.
So what you want, it's very, very difficult to do, but you want jurors that are going to be open-minded and are going to listen to your defense. You don't, but what you also want to make sure is that you have 1 chief and 11 Indians, okay?
Right.
Because if you have too many leaders, they're going to fight with each other, or there's a potential of them fighting, or them getting together and bullying other jurors. So you want to get a group, and there's a lot of science to it, and there's a lot of more luck than science, but because there's no controlling who is on that jury veneer panel. And once that 12th juror is sat, you either won or lost your case at that point, right. Okay?
Okay, we're going to look at the final segment. Again, it's Judge Lane. This time he's talking to the 12 jurors and the alternate. And Noah, go ahead and play that, please.
Let me tell you this. The attorneys and I are going to ask the jurors questions. And we're going to ask each juror one at a time some questions to get to know you. As we do that, we may excuse some of the jurors off of the panel and then call more people up from the audience. For that reason, I'm asking all of you to pay attention during all of the questioning, because it gets to be redundant. We ask the same questions over and over again. Do you have any relatives that are police officers? Have you ever been involved with the DA's office or committed a crime? The same questions over and over. And it gets to the point where, to save time, the parties, the attorneys and I, instead of asking each question when you come up, we'll just say, have you heard anything so far that you'd like to respond to? And so we need you to remember and say, yeah, I sat on a jury 4 years ago and my brother-in-law's a cop, and answer those questions. Sitting at the table, the one on the far end is Nathan Gent, an attorney who's assisting Mr. DeCanio. Mr. DeCanio is the defendant in this matter, but he's representing himself as all Americans have a right to do. This is a great country, and our founders, very smart men, said that citizens have a right to have an attorney, or they can represent themselves, and Mr. DeCanio has chosen to represent himself. Mr. Gent will be assisting him as Mr. DeCanio requires or desires. So I wanted you to take. Is there anyone who disagrees with the statement that a person accused of committing a crime is innocent until proven guilty beyond a reasonable doubt in a court of law? If we were to ask each of you right now if Mr. DeCanio is innocent, not guilty, or guilty, you would all say he is not guilty. You haven't seen any evidence at all. He's an American citizen. As far as you're concerned, he's free to go. He hasn't done anything wrong. And you're the ones who are going to be making that determination after you hear all the facts of the case and apply it to the law. A naked allegation of the charge is not evidence until 12 fellow citizens deliberate on the facts and law and reach a verdict. He's not guilty. There's a cloud of innocence that surrounds this man, and he doesn't have to do anything. He can sit there with his counsel and not say a single word this whole trial, and it doesn't mean anything to us. The only thing that matters is the state going to present enough evidence to you to prove his guilt beyond a reasonable doubt. And if he doesn't say a word the whole 2 days, that's fine. He's not under any obligation to. The district attorney has the duty to dispel that cloud of innocence through the evidence that they present. Do you all agree that every American, including the defendant, has a right to sit there, not say a word, not testify, doesn't have to do anything, and he is still presumed not guilty until proven otherwise? You all agree with that?
There you go. Like I said, I like to follow up on that question because the judge will ask that question, but the jurors, they don't understand the system, most of them, how everything is supposed to work, at least in theory. They understand like a general proposition, but then I will follow up and say, okay, if you had to vote right now, how would you vote? And they would, and then sometimes they'll say, well, I wouldn't vote because I don't have enough evidence. And I go, wrong. The judge just told you had to find him not guilty, and the reason is, unless or until the state proves guilt beyond a reasonable doubt, they're innocent. It only changes when you, 12 jurors, get back in the jury room, deliberate, and all agree unanimously that a person is guilty. Until then, they're innocent. And if half of them can't, or if 11 say he's guilty and one says he's not guilty, then that's a hung jury. I mean, you have to have all 12. So I try to stress the importance of not going in there, because you're not an arm of the court, you're not an arm of the prosecutor, you're not an arm of the cops. You are there as a juror to make sure that the cops are doing their job right. You're there to make sure the prosecution's doing the right. You're there to keep an eye on the judge, literally. And you are not judging the judge, but you're judging the defendant based upon all the things that you see in the trial and what goes on. And I have seen, not my personally, but have friends who have had trials, and the jurors acquitted the person even though there was a lot of evidence, because they felt that the judge and it wasn't in this county, it was in Clark County, but they felt that the judge and the jury were conspiring against the defendant because they were giving the defense attorney such a hard time.
Right, and to me, Judge Lane said a wonderful thing. The problem is we are treated like criminals the minute the police come over and investigate. One of the things Louis brought up at his trial when he was on the stand that ended up being kicked out, not allowed by Judge Lane, but he said that he didn't know what was going on. He knew they were charging him with a crime, but he wasn't allowed access to the police report. He wasn't allowed access to anything. In other words, he was treated like a bum, like a criminal. And the same thing happened to me. I applied twice to get the police report. Nothing. Wasn't until the lawyer. And you told me they do that for a reason, but that's against everything Judge Lane just said. We are treated like criminals through the whole process. We are treated like we are guilty. And the investigation was pathetic in my case. It was pathetic in Louis' case. It's been pathetic in numerous cases I've seen. And I was a foreman for one of the juries.
And what happens I know people that know the DA or know certain prosecutors, and they get like a raw deal from the cops, and say they get a citation or they're arrested, and they go to the DA's office thinking the DA is going to give them a fair shake. And they'll go down and they'll say to Angela, oh, Angela, I wasn't even there. Why are they doing this to me? And she'll just say, well, I can't talk to you. You need to have your lawyer here. Okay, I'll get my lawyer. Oh, no, that's what the preliminary hearing's for. Oh, no, that's what the trials are for. So they don't even want to, and unfortunately, you're not going to get any ear from the DA's office once you're charged criminally. As a matter of fact, they take the opposite position, and anything you say will be used against you.
Absolutely.
And so they may be your friends when you're not charged, but they're not your friends when there's a charger, and they jump on the bandwagon too. It's like, oh, well, the guy must be guilty because a cop arrested him. Well, why would, and as I said earlier in the show, if these cops here, and I can tell you that they're not properly trained as compared to other real world law enforcement agencies, these guys aren't trained right. And I had my last preliminary hearing I did, it was in a felony DUI with death. First cop I talked to, I said, well, you knew that this was a DUI homicide, or alleged, yes, and you knew that you were going to be, you needed to do an investigation for a DUI death, yes. And when you talked to my client, of course, you read her Miranda rights, and you know what he said? No, she wasn't in custody. And I said, was she free to leave? And he goes, well, no. And I said, then she's in custody. No, she's not. I said, do you know what constructive custody is? And he goes, so I said, Judge, can I explain it to him? I got an objection, but then I got to teach him what and I showed him, I said, see this? This is my phone. I have actual custody of this phone. This is in my possession. Okay? Now, see that phone there? It's still in my possession. I'm not touching it. I'm not physically, it's not in my pocket. I got it in my hands, but I can pick up that phone whenever I want, and I'm not going to let you take my phone without my permission. That means I've got constructive custody or possession over it. It's the same thing with custody. If a person is not free to leave, which is 99% of the time when the cop is talking to you, then you are under arrest. You may not have handcuffs on, he may be friendly and talking to you, but if you're not free to leave, you're under arrest. That's called constructive custody. So the cop didn't even know what that was. Then the state trooper came on, and I said, how would you feel if I told you that the first cop on the scene didn't read my client her Miranda rights? And he goes, well, she wasn't in custody. And I go, oh, God, at you too, Brunus? And so the whole point is that these guys they don't understand the law. They're not trained. And I'm talking about even the state patrol guys didn't know it.
Okay, Ray, we got less than a minute.
I know, Tom keeps talking.
I know.
To point out, you might have said it, but I didn't hear it. Louis DeCanio was found not guilty in 15 minutes or less. And when they surveyed the jurors, they said there was nothing here. The reason they charged Louis in the first place, why they pursued it, because he was suing the county for false arrest, and they wanted to get him somehow on some conviction. So that's what it's all about. Keep the faith, power to people. Thank God we saved the Tigers, and we saved them twice. You had a good show tonight. Thank you.
Absolutely. Thanks.
Yeah,
and with that, we got to go.
We do? Oh,
yep.
Shoot, I was just about to talk about an illegal arrest
No
that
way.
a new one I have.
Noah's cutting us off. Thanks. We'll see you in a month.